always take your, you take a date, show them a nice time. We always help them.
This real. This real. I went and checked you out last night. Had to take a picture. I'm not supposed to do that.
We're taking a chunk of it.
Oh, you seen the piece of it?
Dark nights in the moonlight, hop on the back of my ride, strumming on my banjo, headed down a dirt road. Time moves in slow mo, and the crickets sing a melody for you and me. Without you, I don't know where I would be. You're the morning sunrise, always on my mind. When I toss and turn, there's a lesson with you. Hold me like you said last night. Need your eyes just to pass time. Sit on the morning dew. Baby, all I need, baby, all I need is you.
You got a whole album?
And we could run away and make a great escape.
I'm gonna call you.
Baby, you're all I need.
Everything wants to then you want to come to my office?
Baby, you're that
I
would sacrifice just to be with you.
There's more.
You're the morning sunrise. You're always on my mind. When I toss and turn, there's a lesson learned with you. All I is your last night. Need your eyes just to pass time. Sit on the morning dew, baby. All I need, baby, all I need is you.
That's it. Go to me. Huh?
Your life is
Shawty got me broken, hoping we could work it out. Got my toes and twist and turn around. So sleepy, sleeping into the ground. Heart won't allow me to live without you. My eyes wide to the sunrise. I'm sitting with the demon in disguise. I'm reliving with this vivid image. Think of your isolated spirit.
You good on that? So we put on 360? You on, baby. Where is you going? That one to see it?
You can hear it?
You can pull it back. Yeah, pull it back.
You hear it?
Huh? Yeah, like you did before. You push it. Remember we had to push back?
But we can get it.
And you have to really good.
No, I sweat when I smoke.
Oh. But don't stop. Oh, you
Hello.
What's that?
I'm not bringing it.
Okay. We're going to acknowledge everybody's comments today. So I think we got all that together. I hope and I pray that we will. Okay. So hello everyone. Welcome. We're back with our podcast number 13. And we missed a Sunday. Life got in the way. But now we're back to give you all the information that you need free of charge. And if we help one person, then we know that our job is done. So right now we're going to let you talk to, let Shakira talk to you and tell you what our mission statement is, and also to introduce our featured artist of the month.
Hello everybody. Beyond Reasonable Doubt is a visual podcast series focusing on the legal system as it impacts and infiltrates our everyday existence. The mission is to free our minds through sharing knowledge and experiences in order to promote awareness, inspiration, and self-love. And always stay true to yourself.
Amen.
The featured artist for the month is LaShawn the Don. Please check him out on YouTube. And you can also find us on Facebook, Beyond Reasonable Doubt Podcast, on Instagram, BYRD Podcast, and the link is in the bio for the YouTube channel. Please go and subscribe. If you would like, you can call in at 973-877-3737. Have a nice day, everybody.
Thank you, Shakira.
You're welcome.
We love you.
That's not scripted.
Well, it's all raw. We already established that.
Not scripted.
So, and we want to thank Sultan, my son, for helping us with the music part today. It was impromptu. King Supreme, wherever you are, get in touch with me. We want to make sure that you're okay.
Don't do it, Andy. Pray.
What, something was in the way? Could they see you? They couldn't see your face?
They could a little bit.
Okay, we apologize for having the equipment in Shakira's face. We want to always see her lovely face in the place. Now, let me tell you, back to LaShawn the Don. You can also listen to his music on SoundCloud. And let me shout out to my son, Sultan, the king of all kings. Just got accepted into grad school, Cal State University, Los Angeles. So he is on his way to Cali. We're going back to Cali. I don't think so.
Only thing we don't like is earthquakes.
We sure the hell don't like earthquakes. So if he don't make it there, you know it's because his mama said hell to the no. But I would not stomp on his dreams. So we're going to know that God has him in his favor and that he's going to be all right.
Mm-hmm.
So now, we were supposed to be here last Sunday. But, you know, Hamid wasn't here. He had some place to go. My ass was tired. Shakira, she was ready. Oh, come on. Ass cannot be a curse word.
Shakira was tired too.
No, Shakira was not tired. I was tired. Shakira was not tired. She's never tired. And she ain't never scared. Okay, so.
I don't know. I think scared is appropriate.
She ain't never scared. But we are refreshed. I done slept the days away, so I'm ready to go, and I did my research. Now, we were supposed to have, and I don't know where David is. He better be, David Chapman better be joining on.
I don't know if they could hear. I seen the message.
Somebody says you can't hear. That's on you, though.
On me?
No.
I can't.
They can't hear you. Y'all can't hear Hamid on his Instagram, Twin Reed Street? Who's saying they can't hear? Okay, let's hold on a second. So, hey, it's Sim Baby.
Tell my niece I love her.
Love you. Auntie Kira says she loves you. We all love you.
It's hot out there.
It's hot out where?
Shit.
Oh, is it hot out there?
Because it's definitely hot out here.
Yeah, it's hot as what out here?
Hello?
You can hear me now on Instagram?
No, it's mute. It's like there's nothing. I see y'all mouth, but I don't hear nothing.
I must have hit something.
You.
Nothing there. Ain't nothing.
I'm going to end it and play this.
Alright.
Tell Kia.
Hi.
Go to at BYRD podcast on Instagram, and you can see it stream live there too.
Okay.
All right. Okay, so all right, Hamid's having technical difficulties on his situation, but
A lot of glitches too.
I have a lot of glitches. Oh my God! And there's a lot of glitches on our Mevo because we still have the issue with the it's hot and raining in Miami Beach, Florida. Mm-hmm. So the internet is still not working well in this area. So we still have the glitches, but you know, as I always do, the recording always comes out better. So at the end of this live, we will repost the recording and you'll have a full picture of the podcast without glitches or with minimal glitches. So we're here today, and David was supposed to come talk to us about a continuation of the credit. If you guys remember our podcast when our guest David Chapman talked a little bit about credit and whatnot. So he's tired too. So we're going to let him rest. You know I love you, David. We're going to let him rest. And we're going to talk today about Miranda because, Hamid, we've been trying to do a continuation of this Miranda for quite some time now. So I got myself together, and this is what we're going to talk about. So now we discussed Miranda rights, where the law enforcement has to tell you your rights before they question you when you're in custody. So it's the right to remain silent, the right to have an attorney. Anything you say will be used against you in the court of law, and the other things. There was a couple of more. You remember them? Anytime you want to stop and get a lawyer, you can stop the proceedings. They won't question you anymore. And something else that I can't remember. But if you guys were paying attention at the first couple of podcasts, I think we went over all of the Miranda rights. So today we're going to talk about what does it mean to give a voluntary confession. Knowing goes to the issue of your Miranda, whether you were given your rights and whether you signed off, you knew all of that, you were given that information. Voluntary is a little bit different. So it goes to whether or not you made a decision absent coercion to give your statement. So I want to start with a case that's Brown v. State of Mississippi. Brown, hold on one second. Now you know how I'm going to hold on. Podcast. I think that's it. Right on at BYRD podcast on IG?
Yeah.
Okay. So now the case that we're going to talk about, because I know how many the last couple of times that I cited cases and you remarked about how old some of these cases are. Mm-hmm. So this case that talks about a voluntary confession, it's Brown v. State of Mississippi. And the site is 297 US 278, and this is a 1936 case. Before any of us were born, even me. So this is a case where the petitioner. You fixed it?
Yeah.
Did you?
It's separate. It's not all together on IG.
Oh,
It's
it's like
BYRD Space Podcast.
Really? Are you sure?
I don't know.
Well, let's see if she joins in. Did you find out what was wrong with yours? You don't know?
She said it's still popping up.
So, this is a 1936 case, and the petitioner is Brown. Now, back on March 30th, 1934, a man by the name of Raymond Stewart was murdered. And this Brown, the defendant, and a defendant is someone who is arrested and charged in an offense.
The accuser.
The accused, not the accused.
Accused.
The accused.
Yeah.
Okay, that's the defendant. So he gave a confession. So the issue here was whether or not his confession was voluntary or whether it was coerced.
We didn't hear the story, the full story.
Okay, here's the story with respect to the confession. And I'm going to read this verbatim from this case. And if you don't believe me, go to 297 US 278. You can Google this. It will pop up. Brown v. State of Mississippi, 1936. This case was decided February 17, 1936. Here's what it says. The crime with which these defendants, all ignorant Negroes,
wow,
it's in here, all ignorant Negroes, and I pulled these, this is 1936, people, so I pulled this case because I want you to know I'm not making this up. These are the words that were used, and I'm reading it verbatim. I'm not even summarizing it for you because for your edification, you need to know this. The crime with which these defendants, all ignorant Negroes, are charged was discovered about 1 o'clock p.m. on Friday, March 30th, 1934. On that night, one Dial, D-I-A-L, who was the deputy sheriff, accompanied by others, came to the home of Ellington, one of the defendants. So Brown was a defendant, and also Ellington was a defendant. And requested him to accompany them to the house of the deceased, and there a number of white men were gathered, who began to accuse the defendant of the crime. Upon his denial, they seized him, and with the participation of the deputy, they hanged him by a rope to the limb of a tree, and having let him down, they hung him again. And when he was let down the second time and still protested his innocence, he was tied to a tree and whipped, and still declining to accede to the demands that he confessed, he was finally released, and he returned with some difficulty to his home, suffering intense pain and agony. The record of the testimony shows that the signs of the rope on his neck were plainly visible during the so-called trial. A day or two thereafter, the said deputy, accompanied by another, returned to the home of the said defendant and arrested him, and departed with the prisoner towards the jail in an adjoining county, but went by route which led into the state of Alabama. And while on the way in that state, the deputy stopped and again severely whipped the defendant, declaring that he would continue the whipping until he confessed. And the defendant then agreed to confess to such a statement as the deputy would dictate, and he did so, after which he was delivered to jail. So
that's the basis.
That's the basis. Now, there was so the lawyer for Brown, who suffered the same type of beating or violence. It says the other two defendants, Ed Brown and Henry Shields, were also arrested and taken to the same jail. On Saturday night, April 1, 1934, the same deputy, accompanied by a number of white men, one of whom was also an officer, and by the jailer, came to the jail, and the two last named defendants were made to strip, and they were laid over chairs, and their backs were cut to pieces with a leather strap with buckles on it, and they were likewise made by the said deputy definitely to understand that the whipping would be continued unless until they confessed, and not only confessed, but confessed in every matter of detail as demanded by those present. In this manner, the defendants confessed. Confessed he crime. And as the whippings progressed and were repeated, they changed or adjusted their confession in all particulars of detail so as to conform to the demands of their torturers. When the confessions had been obtained in the exact form and contents as desired by the mob, they left with the parting admonition and warning that if the defendants changed their story at any time in any respect from that last stated, the perpetrators of the outrage would administer the same or equally effective treatment. So they confessed after being beaten, and if they ever took back their statements or their confessions, they were going to get beaten again. So this is in the case. It's still saying they can't.
I'm in it. I'll send it to yours.
She never did come.
She told me, she texted me, said she wanted.
Oh, well, I can't see her. So that was the that's in the case. I'm not making this up. I'm reading it to you directly. So
keep pausing.
No, she has. So now the case progressed, and at least the attorney for Davis challenged the confession, saying that it was not voluntary, obviously because they were, beaten and choked and tortured and whatnot. So there was a hearing. So the sheriffs and the people in charge admitted that they had done this to the individual's defendants. And when one of the sheriffs was questioned, he said that he had heard of the beatings. He wasn't participating in it, but he had heard of it. And he said when one of the defendants came to confess, he was limping and could not sit down. That he had been strapped so severely that he couldn't sit down, and already stated the signs of the rope on the neck of another defendant were plainly visible to all. So everybody saw all this. And then it says, it is interesting to note that in his testimony with reference to the whipping of the defendant Ellington, and in response to the inquiry as to how severely he was whipped, the deputy stated, "Not too much for a Negro, not as much as I would have done if it were left to me." So they clearly had no problems with what they were doing, and they thought it was appropriate because these were black people that were involved, and therefore the confession, by any means was voluntary.
And this case is the foundation of the Miranda.
Well, this is just with respect to the voluntary aspect, because Miranda talks about giving you your rights, but along parallel to that development was this other development of whether or not a confession was voluntary. So it moved on its separate track, so to speak. But
they both have a relationship to each other.
Yes, because this case, which predated Miranda, talked about whether a confession was just voluntary. And I put it on the category of deception because without knowing all this backdrop, if somebody signs the confession that it's voluntary and whatnot, then it's presented as something that the person did on their own volition.
Oh, okay. This is a form of forced coercion, right?
Right, exactly. So this is what Miranda disallows, any type of coercion. This is physical coercion because you didn't really, of your own accord, confess. You just wanted them to stop beating your ass.
You didn't volunteer. You didn't volunteer the information.
Right.
They beat it out to say what they wanted you to say.
So in this particular case, this set precedents, and the fact that they had to have a law to tell people this is remarkable in and of itself. But this set of precedents that you can't beat somebody into submission. Yeah. So because of these brave men, and particularly Mr. Brown, who challenged this situation after he was tortured and beaten, all defendants who were interrogated in present time, you can rest assured, for the most part, that they're not going to beat your ass to get your confession or torture you.
They have different tactics, though.
They have different tactics, and we're going to talk about that later. So what this case held is that the rack and torture chambers may not be substituted for the witness stand. The state may not permit an accused to be hurried to conviction under mob domination, where the whole proceeding is but a mask, deception, without supplying corrective process. Nor may a state, through the actions of its officers, contrive a conviction through the pretense of a trial, which in truth is but used as a means of depriving a defendant of liberty through a deliberate deception of court and jury by the presentation of testimony known to be perjured. So, and your constitutional right, which is your liberty interest, which is afforded to you by the 14th Amendment. So this is of constitutional dimensions. Is not only is it wrong to do it, but in doing so, you are depriving the state. In doing so, is depriving. I'm on have. Oh, okay. So something's freezing according to.
The Evo is freezing a lot.
The Mevo is freezing a lot. Okay, sorry guys. For Mevo people, if you want to tune in to at BYRD Podcast on Instagram Live, I think that it's there's no pausing. But if you don't want to listen right now, that's fine too, because I'm going to put the recording up later and it will not have any glitches. It's something wrong with the internet beyond our control. So this is what the courts, the Supreme Court back in 1936 said no. This is what's called a deliberate deception. The state or law enforcement tried to present evidence that these gentlemen voluntarily confessed, but at the end of it all, it wasn't a voluntary confession. They were tortured and maimed, and quite frankly, it was very tragic. So now we know that this is thanks to our predecessors, our ancestors. We now enjoy the comfort of knowing that if the police officers do try to beat us into a confession, that it will be something that will not stand in the court of law, and perhaps you have a lawsuit. You do have a lawsuit.
Well, can we talk about different tactics that they use besides physical tactics? Yes.
So the next case that we're going to talk about is, let me tell you again what this first case was, just in case you missed it. It's Brown v. State of Mississippi, 297 U.S. 278. And this is February 17th, 1936. The next case I'm going to talk about is Chambers v. State of Florida. This is a 1940 case. Still another case.
6 years later.
6 years later, and still another case where all predates us being here, born on this earth. So this is a situation where another type of coercive confession, but not necessarily physical violence, but some type of psychological, mental.
They're playing the mental game now.
Yes, and also the issue here is whether the state improperly obtained a confession in denying the due process law guaranteed by the 14th Amendment, which is what all of this falls under. Now, the facts of this case. At around 9 o'clock on the night of Saturday, May 13th, 1933, a Robert Darcy, an elderly white man, was robbed and murdered in Pompano, Pompano, Florida, a small town in Broward County that was 12 miles from Fort Lauderdale, which is the county seat. So this is back in the day, so things were probably set up a little bit different. Did I give y'all the site to this? 309 US 227 1940. Chambers, Chambers versus State of Florida. So now between 9:30 and 10 o'clock after the murder, the defendant, well, there was I think there were 3 or 4 people here, but there was a Davis and there was a Chambers. Now Chambers was the one that went up, and we have case law based on Chambers' situation. But what they did was law enforcement rounded up about 25 to 40 Negroes, it said, living in the community, and that included Williamson, Chambers, and Woodard, all arrested without warrants, without being charged, and they all were taken into custody. And all of the individuals that were taken into the custody were questioned, and they were questioned for about a week.
Was these adults at the time?
These were all adults, and some of them were taken into a different county. Some were taken to Miami, but they were all locked up in the holding cell or the jail cell or whatever, and they were questioned. They were questioned from around May 14th to around May 21st. May 21st, after an all-night vigil, meaning, they're calling it a night vigil. It was a full night of questioning, nonstop, continuously, and certain people confessed after that, of the whole group of people. So there were 4 individuals, I believe, who confessed, and the only one who did not confess and go to trial. I believe that was Mr. Chambers. So, as an aside, you know, we often complain a lot about, well, you know what, I don't want to digress, but it brings to mind, Hamid, about all of the people who have platforms out there, black folks. And I'm just only mentioning this because these cases have to do with black folks. I mean, these rights that are guaranteed, they're guaranteed for all people, not just black folks. But these black people, in these cases, they were the test people to determine what was lawful and what was not, you know, recognized by the law in terms of how to get a confession. But I think about these people, black folks, and I'm talking about y'all, who are in positions of where they have a platform to speak.
Yeah, like celebrities.
Celebrities, and you know, when I talk about, you don't like me to say ism, you say call it an ISM. I'm gonna call it ISM or whatever. So these people, some of them, and I'm thinking about Kanye West, I'm thinking about Candace Owens, I'm thinking about those two black chicks. I don't know what their names are. Do y'all know who those black ladies are? The Republicans, two black ladies. I'm gonna give the name of them. But how they try to downplay the things that have occurred in our history as black people. And I think it's very irresponsible, because when you if you have a knowledge of these cases, you familiarize yourself with these cases, you'll understand how our ancestors, and I'm talking specifically about Mr. Chambers, stood up.
Yeah. And if it wasn't for him, it probably would led to this.
We wouldn't even be sitting here. We wouldn't be sitting here. We'd be, you know.
People would still be getting taken advantage, going through the same process.
I mean, can you imagine someone now that you just in your house, and somebody dies and you just get rounded up and taken to jail and questioned for over a week period? No formal charges. You don't know what the hell is going on.
Taken away from your family.
Taken away from your family.
Can't even provide for them if you was working at the time.
You don't get a lawyer. No. You don't get anything. You just take it.
Advantage of it.
And so, you know, these people are important, and I think that part of the I'm gonna call it ignorance of some of these people who don't have a clear idea of our history. It kind of damages our future generation in a way. Because you know we're not taught this in the schools. So when you say things like slavery is not a choice, Mr. Kanye West, you know, maybe you come back and say you didn't mean it like that, but just to put that out there in the forefront, just like that, it's a problem. I mean, I think it's a problem, and I think that's irresponsible social messaging. But anyway, I'm going to get back to this.
Well, we lack reading a lot to know this kind of stuff. So when we talk on different subjects, a lot of times you're not even ignorant to some of this kind of stuff. So
or you don't even want to. I would just think, if you were in a position where you didn't have the worries of real life on your hands, like, you know, sometimes, like, people, you know, us regular people, we can't sit down and read. I know this stuff because I'm in law. But you know, you got bills to pay, you got to go to work, you don't got time to be sitting down looking at these cases. But if you're a person like an Oprah or Kanye or whatever, come on now, before you open your mouth, you got time to sit down and look at this stuff and say, hey, listen, what message am I sending out to people who, you know, are listening to me? That's all I'm saying. So anyway, so these guys were, the four of them were held captive for a week, and it says no formal charges had been brought before the confessions, and 2 days after, petitioners were indicted. After the confessions, then they were indicted, then they were arraigned. Williamson and Woodward, they pleaded guilty because they just, you know, you terrified. Like, I could only imagine.
And the same tactics that they used then, they still use them now.
Right, but it gets more subtle, and that's why I'm starting early in the years, because as the years progress, things get a little bit more subtle, and then the courts say that is okay, because it's okay because they didn't beat your ass. It's okay because they didn't take you and hold you up in a holding cell for, you know, days on end. So therefore, it's okay. So anyway, so Davis was the third individual. He ended up taking a plea. Chambers went to trial. So he stood up and said, "I'm not, you know, doing this."
What was the outcome of this?
And the outcome, he was found, he was convicted based just on his confession and the fact that the other guys pled guilty. and he was sentenced to death.
Oh.
Now, this case went all the way up to the Supreme Court of the United States, and we talked last time about how the hierarchy goes. And they found that they did find that this was a violation.
But did he, at the time they found that it was a violation, did he die already?
No, he was as long as you're on appeal, they can't go ahead and kill you while you.
You can still die.
I'm not laughing. I'm not laughing at the death penalty, but I'm just saying.
You could die in jail before you get to that point.
You could
get killed by an enemy.
I haven't noted here where anybody died in this particular case. So I think Mr. Chambers, although he probably went through a hell of a lot.
Yeah. Well,
hell
years.
not being a curse word, and a lot of years off his life. Still, he he persevered. We already said that. What? You can't go back and change it now.
No, you said enough asses, about 4.
How many asses did I say?
About 4.
Give me my 4 pieces of candy then. Okay, I'll take my 4 pieces.
I forgot to get the nasty candies.
Well, okay, so then I get the good candy. That's all. Okay, so now I want to read a couple of things, and you can look this up. I'm not making this up. You guys can Google it yourself if you have an interest in all about your history and where you came from and why.
Well, can I give you a story real quick?
Yeah.
On just a random. So,
yeah.
My daughter had a little incident.
Wait, are you going to talk about your daughter's incident? Because are you sure your daughter wants you discussing whatever incident?
She don't mind. And I'm not using her name. We spoke about this.
But they can. I mean, your daughter. We can. It's a process of elimination.
You didn't even hear the details.
Yeah, because I gotta stop you before the details. Because sometimes you let the details come out and it's too late. Are you sure that she is okay with you discussing this situation?
Yes. I'm not going into. She had a little incident.
She's gonna sip my tea.
An incident with a fight, and the fight stemmed to where the police had came, and the officer took her in for questioning. When he took her in for questioning, they already questioned her before she even got to the police station, asking her what happened, concerning the fight, the little details of the fight. And when they brought her to the police station, they said that they can't go no further with the questioning. They're going to wait to contact her parent and contact her mother. Her mother comes up there and say, yeah, you can question. And I felt some type of way because I'm like, why you ain't call me? I don't think you should, because what if she would have said something that could have incriminated her, and then she would have turned into the suspect. So she wasn't even thinking clear. She just was like, oh, well, I don't think it was. But you don't know. You don't know. So I guess they questioned her and they didn't really go. My daughter didn't incriminate herself, so they let it go. But the tables could have turned, different if she had said something that incriminated herself. So I advised her that I don't think she should have had that, because she wasn't being detained, locked up. She wasn't being arrested at all. It was just for questioning.
Why they couldn't ask her questions where they were at?
Yeah.
If she's a minor, they're not supposed to be asking her no questions without their parent.
Yeah.
So that's the end of the story without further details. That's all right with you?
That's fine. If it's all right with your daughter, I don't. Listen.
I didn't say no name. I got 3 daughters. Which daughter?
The baby.
Baby can get in a fight too.
The baby. The baby just how old is the baby? The baby like 4 or 5. I don't even know if the baby's 5. How old is the baby? The baby is 3. Okay, the baby. It was the baby, y'all. But we had this discussion before on another podcast about how, they're not, if you're a minor, you shouldn't be questioned without your parents, and parents, you should think twice before you allow some law enforcement or school official to question your child. But anyway, we're going to get back to this because this is about grown folks. So I want to hear some of the language that they use here. They say, here the record develops a sharp conflict upon the issue of physical violence and mistreatment, but shows without conflict the dragnet methods of arrest on suspicion without warrant, and the protracted questioning and cross-questioning of these ignorant young colored tenant farmers by state officers and other white citizens in a fourth floor jail room where as prisoners they were without friends, advisors, or counselors, and under circumstances calculated to break the strongest nerves and the stoutest resistance.
I want to give 2 thumbs up for the black brothers that went through it, because they stood strong.
And the Supreme Court justice who rendered this decision and put in some of this language was Justice Black, who I do not believe was black, but somebody can correct me, but I don't think that he was black.
Why not? The wording that he used?
No, I just don't think that he was black. I think Thurgood Marshall was black back then. He was on the Supreme Court, and he may have been the only black judge. But if anybody knows any difference, let me know. But that's my understanding of it. And they also said, here's another. And I just like language, so I just want y'all to. I want to impress upon everybody, what happened to these individuals, and it's not, we have to always remember these things when we go about our daily lives and we complain about how difficult things are for us. If we don't understand how really difficult things were back then for people who were here before us. For 5 days, petitioners were subjected to interrogations culminating in Saturday's May 20th all-night examination. Over a period of 5 days, they steadily refused to confess and disclaimed any guilt. The very circumstances surrounding their confinement and their questioning, without any formal charges having been brought, were such as to fill petitioners with terror and frightful misgivings. Some were practical strangers in the community. 3 were arrested in a one-room farm tenant house, which was their home. The haunting fear of mob violence was around them in an atmosphere charged with excitement and public indignation. From virtually the moment of their arrest until their eventual confessions, they never knew just when anyone would be called back to the 4th floor room, and there, surrounded by his accusers and others, interrogated by men who held their very lives, so far as these ignorant petitioners could know, in the balance. The rejection of petitioners Woodward's first confession, because one defendant gave a confession, and the state was like, the prosecutor said that ain't good enough. Go back and do it again. That
was like the movie. Remember, I was trying to get you to watch the How Do You See Us?
Oh yeah, I couldn't watch it.
Yeah, I don't understand why you couldn't watch it.
Because I read stuff like this, and I don't know. The rejection of Petitioner Woodward's first confession, given in the early hours of Sunday morning because it was found wanting, demonstrates the relentless tenacity which broke petitioners' will and rendered them helpless to resist their accusers further. To permit human lives to be forfeited upon confessions thus obtained would make of the constitutional requirement of due process of law a meaningless symbol. That's some deep shit right there.
Yeah,
give me my candy.
Yeah, now you cut that other off.
All right, well, give me. You like. You think I can't talk with this lollipop in my mouth, but I'm going to let y'all know I'm a multitasker. There's several things I can do at the same time. Y'all who know me know it. Okay, so there's a whole bunch of other stuff on here, and so this talks about. So they said this was no good. So now we say you can't get beat up and tortured, and you can't be detained for a long amount of time in a facility and continually question. And when you say the movie How They See Us, it happened to them, and this is a 1940 case. Now when did that happen to those 5 kids?
No,
70s.
It couldn't have been the 70s. No, it had to be like, I think it was the 90s.
Oh yeah, it was like 92, 92.
Yeah. How much time? We running out of time?
We got 20 minutes.
Okay. So next we could go to so you know, history repeats itself, because they had already said that you can't do it, and they did it to them kids.
Yeah, and this definitely helps the future.
And just so you understand that everything is not, you know, isolated events. Like this is all a historical progression of our lives, and one connected to the other, interrelated. So with that backdrop, you should have a clearer understanding of what your position is here, and how your rights are. Knowing your rights are very important, because if you don't know your rights, then you're liable to get trampled on. Because some people, law enforcement, and this is not an indictment against all law enforcement.
Yeah, you ain't taking nothing away from them. They do their job the way they do it, but you do have to be careful and mindful of the stuff the tactics that they use.
Some tactics that are used, because when it's something charged, like that Central Park thing where the lady got raped and whatnot, that incites the public. So law enforcement might rush because they think they know that someone's guilty. So instead of, or they just want to frame. Sometimes you just want to frame people. That happens too.
Picking people just to
who happen to be in the area, or happen to have some marginal connection to the event, and you just want to bring them on in because you don't have no other leads or whatever. You think that the public needs to know that this was solved right away. You don't want no delay, and all the wheels start churning, and here you are in a situation. That's how easy it is in this legal system to get in a situation. And I'm not saying that everybody who gets arrested shouldn't have gotten arrested. I'm not saying that everybody who's got convicted shouldn't have gotten convicted. That's not what we're talking about. We're talking about knowing your legal rights, and how, if you don't know them, and even sometimes if you do know them, you can get swept up in a system that takes on a life of its own.
And take your life.
And take your life, as did all of these people we talked about. They, before they got up to the Supreme Court, Mr. Brown and Mr. Chambers, they had a substantial portion of their life taken away. Hey, Brown, Derby Cafe. Hi, Trendsetter. Hey, is that Kia? Nakia. Hey, it's Sim Baby. We already said it. Thank y'all for joining in. And if you forgot from last time, Brown Derby Cafe, turkey wings. What's the address? 646 Trumbull Street. Go get y'all some turkey wings. They're delicious. Now, here as an aside, just to give a little break. You remember Shakira was telling us the last time we were talking about talking on the phone, and how she said if you are locked up, also be careful about talking to your cellmates or people there, because you could get yourself in a situation. Well, here's a case called Illinois v. Perkins.
And that's a form of confession too, right?
Yes. 46 U.S. 292. This is a 1990 case decided June 4, 1990. Illinois v. Perkins. 496 U.S. 292, 1990. In this case, undercover law enforcement officer was in the jail and spoke to an inmate who confessed to having committed a murder. And this petitioner tried to get the confession out because he said he wasn't Mirandized. The United States Supreme Court said under these circumstances you could not avail yourself of Miranda, because there was no police interrogation within the confines of the jailhouse, the station house. You were in the jail, thinking that you were talking to a regular person who happened not to be a regular person, but nevertheless, you took that upon yourself. And even though he was law enforcement, you don't get to have that confession kicked out because he didn't give you your Miranda rights.
Wow. Man, that's like entrapment, though.
That's like if you were out on the streets and
right? That's like entrapment.
That's like if you were out on the street and somebody, an undercover cop, was wearing a wire. You don't get no Miranda for that. It's the same concept.
But if he's trying to play both sides, I don't understand how you do that. But hey,
we wait for them to win.
Yeah.
Well, here's what it said. I'm going to read it to you just in case you thought I made it up, because I didn't.
Okay, so that's saying if he's a cop and he's in the room with me playing like an inmate, and I'll say, you a cop? I asked him before I even started talking. You ain't no snitch or a cop or anything. and he say no, would that take away from me the confession still?
Well, there's a whole thing in
He
here.
still should be truthful and tell me that he's a cop, right?
But if the information is viable,
There's cases here that says that they could use deception, which I haven't gotten to yet.
Wow.
So let's talk about this one.
So you can lie?
You can lie, but
Not telling you the truth.
deception and trickery is another form of. It's a tactic. It's strategic
Yeah, but you
law
should.
enforcement tool.
But if I'm out on the street and there's an undercover, and I may suspect that he may be a cop, and I ask him if he's a cop, shouldn't he still tell me the truth?
he doesn't have to because he is.
Well,
Yes, you
can
do.
we wait until the case? Let's get to the case law, because I don't want to just
That
be
would be
speaking.
unique in itself, right?
What would be unique in itself?
If I was an inmate in the room.
Here's the rule. Let's talk about what the law is.
All right.
Okay, here it is. Hell, an undercover law enforcement officer posing as a fellow inmate need not give Miranda warnings to an incarcerated suspect before asking questions that may elicit an incriminating response. That answer your question?
No.
The Miranda doctrine must be enforced strictly, but only in situations where the concerns underlying that decision are present. Those concerns are not implicated here, since the essential ingredients of a police-dominated atmosphere and compulsion are lacking. In its Miranda premise, the danger of coercion results from the interaction of custody and official interrogation, whereby the subject may feel compelled to speak by the fear of reprisal for remaining silent, or in the hope of more lenient treatment should he confess. The coercive atmosphere is not present when an incarcerated person speaks freely to someone whom he believes to be a fellow inmate and whom he assumes is not an officer having official power over him.
Okay, you said felon inmate or
Fellow.
Okay.
In such circumstances, Miranda does not forbid mere strategic deception by taking advantage of a suspect's misplaced trust. The only difference between this case and the other case which they cite, which is Hoffa v. United States, that's 385 U.S. 293, which upheld the placing of an undercover agent near a suspect in order to gather incriminating information, is that Perkins, our guy here, was incarcerated. Detention, however, whether or not for the crime in question, does not warrant a presumption that such use of an undercover agent renders involuntary the incarcerated suspect's resulting confession. Did that answer your question? As disappointed as you may be in the result?
I'm still against it, but you gotta respect this.
So, and the important thing is this, on its surface it sounds like it's so very unfair. But when you get caught up in the situation and you want your lawyer to try to get you out of a situation, and it's like this, see, we have to deal with this law. I might think it's unfair personally. You might think it's unfair personally.
Do you think it's unfair personally?
I do. Personally, I think it's unfair.
Can I get your opinion on that?
Well, I just think that for me, that type of deception is to me, it should be constitutionally unfair, because the person on the other end does not know who he is talking to.
Yeah.
And so if you're law enforcement and your only purpose in talking to me is to get me to confess to you, and you have tricked me like that, because Lord knows if I'd have known you was a police officer, I wouldn't have said nothing.
Yeah.
So personally, I think it's unfair. As a lawyer, when I have to deal with cases like this, I'm bound by the law. I can't get around that.
Yeah, your feelings don't mean nothing.
My feelings mean nothing, and neither do yours.
Yeah.
Neither does the client's. Neither does the judge, for all that matter.
Yeah.
No, because the written law is right here, and this is 1990. So these laws, like you said, they're the concrete. They're the foundation of whatever's going forward. So no matter what we may feel about it, if it's the present law, then it's just the present law, and you can't blame it.
But the unique thing about law is different ways to really work around some of this. If your brain, it gives you it make your profession sharper. Because I've seen some lawyers do some good things getting out of a lot of...
Yeah, it's only good as the law allows. You have if it's a situation like Mr. Brown's or Mr. Chambers, okay, so those lawyers said, hey, something's not right about this. Let's file a motion. Let's make some law, because it wasn't, for whatever reason, there was no law before that said you couldn't get beat up and tortured for a confession. So their lawyers had the foresight to say, hey, listen, let's try it out. You have some lawyers who like, look, it is what it is.
Yeah.
We ain't even gonna try.
Yeah.
And that would be, in my view, the fallacy or the deficiency of a lawyer. If something sounds wrong to you, whether you know it to be right or wrong, or whether the courts haven't even addressed it, if it seems wrong to you, file a motion, because that's the only way that you're going to get it before the court to make a determination. These cases had to go all the way to the highest court of the land, because they got knocked down all those other times, or else they wouldn't have gotten to the Supreme Court. Before the Supreme Court say, hey, you can't hang me and torture me and beat me to, damn near to death to get my confession. To me and you, that would have been like, oh, of course you can't do that.
Yeah.
But back in 1936, would we have been saying that?
Common sense was a little different.
And it took that judge, Justice Black, in the one case, and then the other case was Justice Hughes in the Brown case, and then Justice Black in the Chambers case. And in the Perkins case, where they said that it was okay, Justice Kennedy. And Justice Kennedy is the same justice who retired. He just retired.
Yeah.
And that's how
he was on the bench that one.
And that's how Judge Kavanaugh.
He was on.
Wait. Yeah, it's 1990. Yeah. That's how Judge Kavanaugh came in, because of Justice Kennedy's retirement. So we're going to continue this the next time around, because the hour is winding down. It's a lot to digest, but we have situations where this is the Supreme Court of New Jersey. We'll talk about this, where a defendant asked to speak to a family member, and the state of New Jersey says, under these circumstances, when the defendant asks to speak to even a family member, you got to stop your interrogation, because they have the right to remain silent. Not that you have a right to talk to that family member, but you got a right to remain silent, because if you say, look, I want to talk to my mother or my father before I decide to do anything else, that means that you've evoked your right to be silent, and law enforcement have to respect that. So that's going to be our discussion on next time. And I'll just tell you that this is for New Jersey. State of New Jersey v. Maltese, Maltese. And this is a Supreme Court case decided August 17, 2015. It's 222 NJ 252, 2015. That's a more recent case. And then we also have a case where this is a situation where an individual, this was a case out of Connecticut. It's Rogers v. Richmond. And this was a situation where somebody was killed. And they threatened the defendant, if you don't confess, we're going to go get your wife and lock her up.
Oh, yeah, they use those tactics too.
Yeah, so we're going to talk about that. And there's a case here that talks about a situation where an individual was told that the victim had just passed away when the victim was found dead. So these are little lies and deceptions and trickeries, and we'll get into the nuances of all that the next time.
But those deceptions is not allowed to use, though, right?
Some of them, you have to look at the case law. Some of them they allowed them, and some of them they did not allow them, and some of them were remanded back down for a further consideration.
I think deception is just lying, period, to get what you want is the wrong way.
And the case law, I'll give you a teaser. The case law is this: deception and trickery is okay, as long as it does not prompt the confession.
Explain prompt to the people. Okay,
so as long as, if your confession was not, and it's not a but-for type of situation, but if if whatever the misinformation that was given to you results in the confession, then there's a problem. If it doesn't result in the confession, then there's not so much of a problem. And I have to get, the standard is totality of the circumstances. So in the one where the wife was going to be arrested, which was a lie, the courts had a little bit of a trouble with that. In the one where they lied and said the victim just died, and when the victim was already dead when they found her, they didn't have so much of a trouble with that. So it's all the standard is a totality of the circumstances, and they look at certain factors about the individual, your education, if you ever been in trouble with the law before. You know how they kept saying ignorant Negroes? They took that into consideration.
That's concerning the confession. If the defendant confessed and he didn't understand
whether he's susceptible to coercion for psychological.
Oh, okay.
So if you're a defendant, if you've been like locked up a few times and you know the ropes, they take that into consideration. Like, okay, you can't be easily coerced because you know what the deal is. So they take that into assessment in totality of the circumstances. But we'll get into that next time. So we can discuss the little nuances of how things are determined in the area of coercion, deception, and whether your confession was voluntary or whether it was against your will. I have a direct quote that I wanted to give you, and I hate when I'm running out of time because I can't find my here it is. Here's one of them. So it's saying that in our society, criminal law, it's an accusatorial, not inquisitorial system. So you're accused of a crime, but it's not like the Inquisition. Like you're not. It says that ours is an accusatorial and not an inquisitorial system, a system in which the state must establish guilt by evidence independently and freely secured, and may not be coercion prove and not by coercion prove its charge against an accused out of his own mouth.
Yeah, I like that.
Yeah, that sums it up. Yeah, that sums it up.
But they don't really go by it.
No, they don't. And push my button. No, they don't. And that's what we are going to discuss more in detail the next time that we come. We hope you guys enjoy. Join us next time. And as we lead off, do we have music or we don't have music? I don't think we have music. And we can say we could say goodnight.
Good night.
Say good night.
Good night.
And we'll see. Yeah, you're right here. And we'll see you next time. Thanks for joining us. And we're going to put on the clear version of this podcast later on tonight because I understand that there was a lot of glitching. All right, guys. Peace. Say goodbye, Shakira. Bye. I never know how to work this thing.
That's deep.
Sultan, are we stopped? Because
I'm never get no more trouble. Like,
no, you're not going to get into no more trouble. Did we already make that clear?
Yeah, I can make it clear, but also just do some something.